Representative Clay Doggett from Tennessee, I really appreciate you joining us on Marcy's Law interview series, Why We Do What We Do. Really busy time of year, back to school, college football in the Doggett house. We know we've got high school football and all the other sports that you and your family have to participate in, as well as being a very busy Tennessee state legislator. So thank you so much for all the work that you do and for joining us and taking so much time to help Marcy's Law over the years. Um, we started this Marcy's Law interview series, Why We Do What We Do, several years ago to highlight the people who are advocates for survivors and the victims' rights community. And I've been blessed to have so many different people from different states. And we've been focusing on Tennessee because we're going to be on the ballot in November. And that was a long, several year process that you were instrumental in helping us with. So I appreciate that. I want to talk a little bit about that. But we've had leaders, some of whom have been through terrible, terrible tragedies, who have turned what they call their pain into a purpose. And then we have the people who stand by them and support them and put them on their shoulders, like you, legislators who have been devoted to victims' rights causes, to law enforcement issues like yourself. I want to talk to you a little bit about what got you involved in becoming a public servant and a state representative, and then talk a little bit about how you got involved in victims' rights, some of the different pieces of legislation that you have spearheaded and passed, as well as your involvement in Marcy's Law, how that started, and how committed you are to it. So let's get it started with you started in law enforcement and you started a small business. How did you start with law enforcement, and how did that lead you to running for state rep in Tennessee?
Well, good morning, and thank you for having me as a part of this with Marcy's Law. I had I had often thought about wanting to get into law enforcement when I was coming out of college, and finally an opportunity came where I could serve in the community that I live in Giles County, which is southern Middle Tennessee, and got into law enforcement with the hopes of one day being an investigator or a detective, and fell in love with patrol. And patrol is really the first line of interaction between law enforcement and, in my case, and with victims. People would call 911 when they had an issue that had arisen and they needed assistance. And so found that I was dealing with a lot more victims in law enforcement than I was with actual perpetrators. Um, but I got into law enforcement. I really enjoyed that. While I was there, I started a small business to help supplement my income on the side, and that business grew to the point to where my wife and I discussed that we would step away from law enforcement and run the business full time. And it wasn't much longer after that I was approached about running for the state house seat in our area. And so I ran in 2018 and was elected to the Tennessee General Assembly, and began serving in 2019.
And you are currently the chair of the Criminal Justice Subcommittee,
That,
and you remember the Judiciary Committee as well.
that is correct. When I first came into the legislature, you get a form that you fill out that in Tennessee that says, what committees do you want to serve on? And the Speaker of the House is the one who appoints all the committees. And they look at your biography, they look at your background to see areas that you might have some strengths in, identify some areas that you may have some weaknesses in, and then areas that you can contribute with different perspectives. And so I've been blessed really to serve on a number of different committees, but one of those committees that they put me on right away was Judiciary back in 2019. And so I served there, and then on that Criminal Justice Subcommittee. After completion of that first term, I was appointed to chair the Criminal Justice Subcommittee, which the bulk of all criminal law for our state comes through that committee. So we're a very busy committee. We consider about somewhere between 300 and 400 bills every General Assembly, which is considerably more than most other committees.
Yeah, and we at Marcy's Law gained a very quick appreciation for how busy all of you are as legislators when we first introduced the concept of Marcy's Law to the great people of Tennessee, all of the different stakeholders in the victims' rights community and the law enforcement community, and people like yourself and the legislators. Because one of the things that some people might not realize, we are going to be on the ballot in November. But this doesn't, we don't just walk into the Secretary of State's office and say, we are Marcy's Law and we're passed in many different states around the country. And we now want to get passed in your state and would like to be on the ballot. It is a long process, a several year process sometimes, which is driven by the people. And it's driven by the people of each particular state and the great people of Tennessee that I have gotten to know, that we have gotten to know over the years, from incredible victims' rights leaders and all of those stakeholders, the Domestic Violence Coalition, all of these different places, all of the different law enforcement, all the different prosecutors that we've had a chance to meet and be blessed with knowing, and then the legislators. And we introduced it to you. And tell us a little bit about Marcy's Law and your first introduction to it and how long it has taken and the exhaustive process that you've gone through.
Absolutely. So just even with, regular legislation, a bill that's a law change or a new law, that can be a very grueling process in itself. But constitutional amendments are especially grueling because the way our Constitution is set up, the amendment has to pass two different general assemblies. Then it has to be on the governor's ballot after that. So it's at a minimum a 4-year process if everything goes right for that to have an opportunity to be on the ballot. And when Marcy's Law was first introduced to amend our Constitution, putting enforceable victims' rights in our Constitution, we already have currently today a Victims' Bill of Rights in our Constitution. Now, it's things that people are very familiar with, but yet they're not really enforceable, and they do not go to the level that Marcy's Law does. And so when we talk about, and you and I have spoken about this before, two of my most favorite parts of Marcy's Law is one, the right to be heard, and the notification piece, that of every time, every step through the judicial process, you are going to have that opportunity to be notified and then the opportunity to be heard. Those are really big deals there to me because of things that I've experienced in the past with individuals in the criminal justice system, seen what has happened to them, heard their stories. And then with the large number of people that have come to Nashville over the past several years advocating on behalf of Marcy's Law. Some of them didn't even know what Marcy's Law was. They just had issues. But when they had learned about the opportunity for Marcy's Law to be on the ballot, to rewrite that section of our Constitution and what that can do for them and their families and their communities going forward, it's been really good.
Yeah, and we appreciate the experience that you brought with you. That's why I wanted to start with that, to the legislature, because you had real life experiences, and you and I talked a little bit about as far as the opportunity to be heard and how it would frustrate you sometimes and make you, and when you would see, in your position in law enforcement, you would see someone in the courthouse after something had been resolved. And tell us a little bit about some of the experiences that you had with that when a case was resolved and a victim felt like they had no idea what was going on.
Well, absolutely. You have something that has happened to someone. Maybe they're a victim of they're certainly a victim of a crime, maybe domestic violence, maybe something else. We initiate the process. The defendant is brought into court, a subpoena for the witnesses to the victims to come in. It's a long process. They sit in court for multiple hours waiting for their turn just to find out that the case had been dissolved or had some type of agreement between the prosecutor and the defense, the victim was never once questioned. They were never once spoken to about what they would like to see happen. And so we get up and leave the courtroom and go out into the hallway, and they say, Clay, they never talked to me. They never asked me anything. I've sat here all day and I'm not even really sure what just happened. And that wasn't just one time. That's a lot of times. And I know that in every small town and large city that the prosecutors, when they go to court, they've got a multiple cases. I mean, the docket is huge. They're trying to go through and dispose of as many as they can. But, people would leave the courtroom and they did not feel whole. They never had their opportunity to speak. Perhaps the only notification they got was 3 days before, 5 days before, when someone like me showed up at the door with a subpoena. They had to take off work to go to court. And then no one ever consulted them at one time to see what their thoughts were or really what they wanted to see happen going forward.
And now, with Marsy's law, when Marsy's law is passed, hopefully, now victims will not just have a right to be heard, but an enforceable constitutional right to be heard. One of the other great pieces of Marsy's law and great constitutional rights is the right to be notified. Right to be notified when a defendant is released on bail, right to be notified when there's a parole hearing, right to be notified when somebody is paroled or if they're moved from facility to facility. You have firsthand experience as a legislator and talking about a case where notification was the critical issue in a domestic violence case. Tell us a little bit about the Debbie and Marie Domestic Violence Protection Act, what that does, how it came to be. And I know this is a piece of legislation that you're proud of and that you spearheaded, and it is very important as far as victims' rights go and for protecting victims.
Absolutely. Well, it's an extremely tragic story from the suburbs of Nashville. A few years ago, Debbie Cisco and Marie Varso, a mother and a daughter. The daughter, Marie, her husband had abused her, and at any rate, she had left their home and went to her mother's, was staying there with her children, and her husband was released. She didn't know. At the same time, he found her and tragically gunned her and her mother down one morning after school had started. Very sad. So how that came to me was the victim's family approached me and asked about what can we do. One, we've got issues with notification, but two, also with added protections that can help victims of extreme domestic violence. So in Tennessee, we call it aggravated domestic, which would be a felony domestic assault where a weapon was used or someone was put in fear of their life or serious bodily injury. Now, before release, they have to have that GPS device. Also, the victim has an opportunity to get an app or some type of additional notification device on their phone so that they get that notification when the defendant is within their area, which is huge. And so just shortly after that bill passed, we had not only constituents in my area, but I had people from across the state were calling to say thank you because for the first time they felt safe and somewhat secure because they were not afraid to leave their homes. Before that, they still had fear from their abuser, which is very normal. But for the first time, they felt like they could go on living their lives because they had that added sense of security.
So this is even when pre-trial, when a defendant is out on bail.
Absolutely. So prior to as a condition of their bail, they have to get this device secured to their person. And then they have parameters. All the things are put into areas that they are excluded from going. The victim's home, workplace, perhaps school, church, different areas like that where the victim is known that they're going to be. Those areas are excluded. And if the defendant, if the abuser enters that area, then the victim gets immediate notification. So does law enforcement.
So the the GPS service provider then, my reading of it is the GPS service provider has to automatically notifies the victim through either a phone call or an electronic receptor that the victim has. And the law enforcement that is assigned to that particular case or that particular jurisdiction, they get notified as well by the GPS service provider.
That is correct. So it goes both ways. The GPS provider has to have a 24-hour monitoring center, very similar to that of a home security system. So as soon as the defendant, the abuser, gets within that zone or the whereabouts of the victim gets notification at the same time. The appropriate law enforcement jurisdiction gets that notification as well.
Yeah, that really is an incredible piece of legislation that congratulations, you should be incredibly proud of that. It's going to save a lot of lives.
Well, thank you.
And prior to that, when you first started as a legislator, you were telling me about a case that that actually was the impetus for another piece of legislation. I think it was the Leanne Act, and it talked about how protective orders need to be enforced statewide, which is one of the things that we talk about is enforceable constitutional rights. One of the obvious things is if it's an enforceable constitutional right, it's statewide. But tell us a little bit about that piece of legislation that you were telling me about, where you had protective orders that needed to be enforced statewide, and what the case was that sparked it.
Absolutely. So up until I think it was 2019, it may have been 2020. If there are many different remedies that a victim of domestic violence has at their disposal, but one of those, of course, is the orders of protection. But sometimes a judge may not grant those, but they may grant a no contact order, meaning that the abuser cannot have any contact with the victim, whether it be in person, whether it be by telephone or text message, email, whatever the case may be, they're not allowed to have any contact with the victim. If the victim receives contact from that abuser, they have to first notify the judge of the jurisdiction that issued that no contact order. So in most of these cases, some can be in city courts, but most are in county courts that they get these orders. And the order was only good for that county. It was not enforceable outside of that county. So if someone lived in Davidson County and had a no contact order, but yet they went to a high school football game in Rutherford County, which is the county over, and saw their abuser there, the abuser made contact with them, they would have to contact that Davidson County judge, but then it wouldn't be enforceable there in Rutherford County. And so, and that's another thing that I'd recognize from law enforcement. But I had a victim's family, the Hensleys. Leanne was a young lady about 20 years ago that she had been in an abusive relationship. She had filed multiple times on her abuser for violating the contact order. And just 2 days before her death, she had also made another complaint that her abuser had made contact with her. She was in fear. The young lady worked about 30 miles from where she lived. And so one morning she got up, she told her parents goodbye. She grabbed her lunch and her purse, got in the car, headed off to work, drove 30 minutes to work. And when she pulled into the parking lot, she shut the door and locked it and turned around, and there was her abuser. And he shot and killed her there on the spot in the parking lot at work. And so it's an extremely tragic story. Her dad still actually travels the country to tell this story. but he had approached me and asked, he said, Clay, we've tried multiple times over the last several years to get something done to help others who may have found themselves in a situation of abusive relationship to where they can get some protection, not only where they reside, but when they go statewide. And so we sat down and began working on the legislation. So eventually the product we came out with was we made those no contact orders enforceable statewide. So if an abuser has a no contact order put on them, it can be entered into a database like such as NCIC, to where if the victim ends up in Pigeon Forge, Tennessee on vacation and encounters their abuser from Dyer County, Tennessee, uh, they can call 911. Local law enforcement can respond. They can verify that order, and they can remove the abuser from the victim. They can arrest them and take them in for violating that order. And so, you know, this, along with the Debbie and Marie Domestic Violence Act, they really coincide with the mission that Marsy's Law has, because it's going to give victims greater opportunities, not only for safety, security, but enforceability of their rights through the court system.
Yeah, that's a really good way to summarize it, Clay. And these are things that really, literally save lives and protect lives. And another area where you've been instrumental in helping victims is making sure that victims can be financially whole, and that their restitution is paid. And there was something that you changed in Tennessee law, that you helped change in Tennessee law, where restitution became a priority. Tell us a little bit about that, how you made victims' restitution a priority in the criminal justice system in Tennessee.
Yeah. So again, from my experience in a small town in law enforcement in Tennessee, would see where someone was victimized, victim of a crime, a judge would order restitution to that victim to make them whole. But the way our statute read, victim's restitution was the very last thing, the very last box to be checked in the process. So the court costs and the fees and the fines, all of those things were paid first. They received the first dollars from the defendant. And then by the time all of those costs were satisfied, there was nothing left for victims' restitution. And the victim had to, there was opportunities to get that back. They would have to go through, you know, garnishing wages. They would have to go back through the courts to get an order. But we found a lot of times they were never received the first penny. And so speaking with some colleagues and some victims advocacy groups, we reprioritized that section of code to where victims restitution came first before anything else was paid, because the main focus of that was victims, to make sure that victims could be made whole. And we've been doing that now for almost 6 years, and it's helped change people's lives as well. It's something that I'm also very proud of.
Yeah, well, it is clear that you really are the perfect example of someone who becomes a public servant for all the right reasons and brings with you the life experiences that can relate to people who come into your office with a problem that needs to be solved. And these few examples point to probably why, and you're too humble to say it, so I will. You were recognized by your party as the Tennessee Legislator of the Year in 2025. So congratulations for that. I also want to thank you, to finish kind of how we started, for all of the support that you have had, and you have brought your colleagues along with you as well, for Marsy's Law on behalf of victims all across Tennessee, to make sure that they get enforceable constitutional rights. It has been several years, and I will say that you and your colleagues work so hard to get it right. And it wasn't necessarily an overnight proposition in an overnight sell. You and all of your colleagues wanted to dig into the details, not because you didn't like the idea, of enforceable constitutional rights on the ballot because you thought on behalf of the people that you represented in all of this great legislation that you have passed along victims' rights, that you want to make sure if it's passed, it's going to be able to be implemented correctly. And so we all work together, and now we're on the ballot. So I thank you so much for being so attentive to detail to make sure we get it right. And you know from working with our state director, Bonnie, that we are a presence in Tennessee, and we will continue to be because we want to make sure that Marsy's Law, if it's passed, is implemented correctly. We'll have a presence. That's what we do in states is we stay and make sure we work with law enforcement. We work with victims' rights advocates, but we also continue to work with legislative leaders like yourself who have such a passion for victims and victims' rights that we make sure that we get it right in the implementation. So I want to thank you for all the work that you've done, the years-long commitment, and our continued relationship as we go forward in Tennessee to try to work together with all the stakeholders to make sure that victims have enforceable constitutional rights in Tennessee. So thank you so much, Clay, for all your years and for taking your time today.
Thank you so much. It's an honor.
Thank you, Clay.
Thank you.